This is Law Bites, a podcast with Michael Geist.
The bill I am introducing today will do just that for Canadians. It will not only modernize Canada's privacy regime, but it will also introduce new measures to support the responsible development of artificial intelligence in our country.
Earlier this summer, Ryan Black joined the Law Bites podcast to discuss the privacy aspects of Bill C-27, Canada's privacy reform bill introduced in June by Innovation, Science and Industry Minister François-Philippe Champagne. But the bill isn't solely about privacy, as it also contains the Artificial Intelligence and Data Act, the government's attempt to begin to scope a regulatory environment around the use of AI technologies. Florian Martin-Bariteau is a friend and colleague at the University of Ottawa, where he holds the University Research Chair in Technology and Society and serves as director of the Center for Law, Technology and Society. He is currently a fellow at Harvard's Berkman Klein Center for Internet and Society, and he joins me on the podcast to break down the AI portions of Bill C-27. One programming note before our conversation: the Law Bites podcast will take a brief hiatus for the rest of the summer and return in September. Florian, thanks so much for joining me on the podcast.
Thank you for the invitation.
Okay, it's really nice to have a friend and colleague come on. As you know, and many of our listeners will know, the government fairly recently introduced Bill C-27, which has got a lot of attention on the privacy side. And I had an earlier podcast with Ryan Black that focused on the privacy-related reforms coming out of that bill. But it's a bill that's about more than just privacy. Included as well is the Artificial Intelligence and Data Act. So I'd like to get into what's in the bill and how it compares with some other jurisdictions, but I want to start very broad from a policy perspective for those that haven't given a lot of thought to AI and issues around regulation. But I guess the basic question of why regulate AI? What kind of concerns are we trying to address?
Yeah, so as you said, it was a bit of the surprise of C11 we were all expecting. The reintroduction at some point of the former C11. And so we had that AIDA, AI and Data Act. So why regulate AI? Well, AI, has been all over the news in the recent years, especially during this pandemic when our lives moved fully online. And so the rise of AI, or at least the so-called AI, because we can discuss this later, but AI is often used as more like as a marketing term, but more and more we have autonomous or semi-autonomous systems that are being deployed in our everyday lives, from ordering food to going to the cinema to our shopping experience to online, what we're seeing on social media, like the vehicles, facial recognition used by law enforcement agencies, or even by in the shops, etc., medical devices, autonomous contract, all the new tools being deployed in the so-called smart cities, etc. So there is a lot of use of AI, especially in government, also, that have been raising concerns of bias because of the way those systems are trained on biased data, or the way they are designed, amplifying current injustices, or just creating new way of harming, especially marginalized communities. And we also had AI systems that are faulty. I'm thinking of some autonomous vehicles, or issues with some airplanes, or with some contract system, or the autonomous system kind of went rogue, wild. We had social bots, like bots on social media that went wild and racist, etc. So we saw a lot of issue in the past years that led to call for regulation, sometime to ban. There's been a lot of call to ban facial recognition used by law enforcement and by corporations around the world. And why regulate this? Because so many issues, and we have legal framework that applies, but they're often imperfect, or like they're gonna apply it's going to be very complex to apply them to those new situations and to a fully autonomous agent. And often, rather than looking at the hard law and doing like the hard work of thinking on how to interpret our statutory frameworks, we went on to rely on soft law, code of ethics, policies. So very nice tool that can be helpful to help design and think through, all of those systems. But there is an issue on the enforcement side. And so in that act, I think this is, at least on paper and based on the press release, what the federal government tried to address, but on focusing on the use of data in AI system.
Okay. So a lot of sources of different kinds of concerns, everything from bias in AI to, bots run wild and who's responsible where some of these kinds of things occur. And you're right to highlight that much of the approach in the past has emphasized more softer approaches, and we've seen this gradual shift. What kind of laws or rules do we have right now around, let's say, corporate misconduct or some of the biases that you just identified? Are some of those laws capable of dealing, in your view, with some of these issues, or is this the kind of thing that is long overdue or just overdue, given the inadequacy of what we have in place right now?
So I think the very legal answer is like it depends / all of the above. It's very much like we need to have a kind of case by case approach. A series of issues have been addressed by courts in Canada or around the world, implementing general doctrines for contract, for torts. Privacy rules, etc. They definitely apply to most AI systems, to most corporate behaviors that could be harmful. It's not because you're using an AI that you're not governed by the usual rule of law. Although some concepts and some approaches in those legal doctrine have been developed in a society of another age, especially if we think of torts, of contract, but to be honest, most of the issues that we're seeing for AI system are not just AI specific. When we think of some of the issue with the deployment of contract and standard form contract for AI system, as you know, we had the same over the internet, or the idea of consent with privacy. Again, it's not an issue that's proper to AI, but when you look at some deployment of AI system, it amplifies those concerns. So we don't really need new laws for everything, but in some cases we might need some new rules for some autonomous or semi-autonomous system, because they lead to a paradigm shift or to very new behaviors that we never had before. And most of all, beyond just having principle in the law, rules, we also need, in my opinion, enforcement agencies with regulators with order-making powers, with fining powers, not just sweet code of conducts and ethical guidelines. And so that's why there was all those calls. There has been a lot of conversation about automated decision-making, notably in the public sector and at the federal level. We have the Treasury Board directive that's imperfect, but at least provides some guidance on the use of some AI system in the public sector. Quebec just reformed last year the privacy law, so for automated decision making and the use of the processing of personal information. So there is some tools, same for tort law, but it's imperfect. For example, when you look at tort law, when you look at non-intentional harms, for some very autonomous systems and some like remote arms, it might be very complex for Canadians to be able to obtain remedies from the courts. So this is why there's been called to develop like more better legal frameworks, and also with algorithmic accountability and right of action for citizen and enforcement powers to make sure that corporation will follow suit.
Okay, so you've made a good case for why there are some holes at a minimum in terms of the frameworks we got right now, and there's a need for some of these rules. I want to come to what Canada has in mind in the bill in just a moment, but before I do that, this bill is, as I said off the top, included within what I think is more broadly known as a privacy reform bill. That's where the emphasis has come from, and there's oftentimes a link made between privacy and AI. In fact, even within the privacy part of this bill, there are some provisions related to algorithmic transparency. Can you highlight, in your view, where some of these differences lie? What is the difference between some of the core privacy issues and algorithmic transparency as compared to some of the AI-related issues that you've just been citing?
No, exactly as you mentioned. That's why it was kind of a surprise to see that act included, and it felt almost like at the last minute, in the new C11, at the same time as the official title of the short title of this of C11 is the Digital Charter Implementation Act. It kind of makes sense because in the infamous Digital Charter that was just like, in my opinion, an electoral platform for the Liberal Party in 2019, there was like a mention of AI system, etc. But in my opinion, like AI is way better than the like issue raised by AI systems, or more than just privacy. For sure, privacy and data are like a big part of AI systems, because this is also where we've seen the biggest issues, especially in Canada, with the Clearview AI scandals, with and many other like privacy scandals. But as I mentioned earlier, issues are like more diverse than just privacy. Privacy is just like one aspect, one area of the law that we need to reform and to adapt to the AI age. And so algorithmic transparency would also require like changes in the tort frameworks in contract law, etc. That, and we'll discuss it later, that C11 doesn't address at all. And it's almost kind of strange to see like AIDA, because it's so much like privacy oriented and data oriented, but one is to consider why it's not included in the first part of the act, because one of the main regulated activities is processing or making available for use any data related to human activities for the purpose of like designing those AI system. That's very much like privacy reform. Why not including it? The act also discussed a lot, anonymous data, but without any kind of definition, while we have this definition in CCP. So it's kind of strange. It almost feels like it would be like more like an extra, a new section in the CCP than an act by itself.
Why don't we start with how the bill seeks to define an AI system, and what kinds of activities does it seek to regulate?
Yeah, so that's kind of the first point that raised concern, I would say, in the bill, is what is AI, and nobody is able to define what is AI, and the government tried to propose a very strange definition that nobody really knows exactly what it covers. It's very broad, so we welcome broad definition. It allows to be able to welcome new behaviors that we may not have been able to think of when we design like legal framework. But sometimes it may be too broad. We don't really know what is included because so it's autonomous and semi-autonomous system. They're like technological system that processes like data. They might be also relying on other techniques. Nobody know what, or like other techniques to generate content. If you're thinking of like other conversion we're having right now in Canada, like a technique that generate content can be pretty much like anything. So it's very broad, maybe too broad. I'm guessing this is something that's going to be heavily discussed. As to the regulated activities, what is covered by the Act. So first you have like processing and making available any kind of data relating to human activities for the purpose of designing, developing, and using an AI system. So very broad. And then it also meant to regulate the designing, the development, and the deployment of such AI system. So in the world, it's very broad, which is good. It's really meant to cover all kind of AI related activities. And the purpose of the Act is to regulate, international and interprofessional trade and commerce of AI system and to prohibit such certain conduct. And that's a constitutional concern, the usual battle between the federal power and the province. And this is the way the federal government is calling upon their jurisdiction is to use international trade and interprofessional trade and commerce. Maybe we can discuss it later. It kind of makes sense, but also bring like some limitation. And one of the biggest maybe limitation of the Act, and there is no constitutional explanation, is that the whole public sector has been deemed out of scope. We don't know why, because for sure the federal government has competency to regulate the public sector, and we have already like tools that exist. So we would have, expected the federal government to build on existing the existing directive to show the way to, especially to the corporate world. And also there is an argument to be made that when the government deploy only very ethical system and have like a procurement pipeline that force the provider to respect a set of good practices and documentation, it's just going to force the industry to update. So that would have been welcome, and we don't really know why they can be excluded. The government can also exclude any kind of other organization just by regulation. So that's an issue. But again, that's a good thing. On the other hand, is that they cover all aspects of development and deployment of AI.
For those that find themselves inside the tent, so I recognize you saying that there are any number of different kinds of AI systems that might have been included that are not, but to the extent to which there are some that are, and I know there's a bit of a focus on what might be thought of as high impact AI systems, what requirements does the legislation actually establish? So once they've identified what's in, what kind of requirements are included within the bill?
So that's actually like you put your finger on one of the biggest issue in the Act. So it's very complex. It's like you need to read it like several times to fully understand like the exception to the exception to the exception. But also, actually, in the Act itself, there is not much. Almost everything that matters is delegated to regulation, including exactly who is covered, who is not covered. What do you need to do? The approach overall for like AIDA is all about like transparency and documentation, which is good. Although we don't really know what kind of transparency and obligation and documentation obligation will exist, because that will be defined in regulation. And transparency and documentation might be very good, and we call for this, but there are like two risks. First, an overload of information, because there is like transparency and also like obfuscation by too much transparency, and sometimes the documentation could be used an excuse to more violation. But it was somewhere in the document, it was buried somewhere in the documentation, so it's almost an out of jail card, and I will come back to this. This is also one of the issue, the provision in the Act. But so, as you mentioned, the Act appears to have a focus on high impact AI system. There is the Act says that there will be a set of requirements and rules for all AI systems to be defined in regulations, and then there are extra requirements for high impact systems. Although I am unable to tell you what are high impact systems, because that will be defined in a regulation. So will there be different level? Will there be low impact, medium impact, high impact system like we've seen in other pieces of regulation in Canada or abroad? We don't know. Well, based on the context, on the overall framework of AIDA, high impact system will probably be AI system that will have a reversible effect, on Canadians because of the bias that they create, or the harms. Would it be material harm, so physical or psychical harm, or the damage to an individual property, or the economic loss to an individual? So if they have an effect that could not be remediated, that would be an high impact system. But that's a wild guess. If I look at the other provision of the Act and some other practices, that's one of the issues. Maybe would have welcome. It's good to rely on regulation, to have a flexible framework, but too much regulation, it's also a lot of uncertainty, both for Canadians, but also for corporations, because basically we have an Act that has could be a nice shell, and it's not, in my opinion, but it's kind of an empty shell at the moment. And so, especially high impact AI system will have a lot of documentation obligations and transparency obligation. They will need to develop check and balances, system, and monitoring system within the organization to make sure that the AI system behave as it was expected. But again, we don't really know exactly what it will mean, because those obligations ought to be, you will guess, defined in regulation. Although we know that all that documentation for all AI systems should be in plain language, but as you know, and I'm sure your auditors know, plain language is a double-edged sword. We've seen that is not working that well in the privacy area. One good thing, although, and a very important requirement in AIDA, is that a person who is responsible for a high-impact system will have the obligation to notify the minister if the use of the system result or is likely to result in material harm. So there will be not just documentation, but you will have to proactively inform the minister, which is good. But then, what does it mean? Does it mean that then the minister will put in place specific and more in-depth auditing of the organization of the system? We don't know. Again, we guess / hope that it will be defined in regulation.
How does the government plan to enforce all of this?
That's a very good question, and that's also a question that's raised by the recourse to the criminal offenses and criminal power, because there's also two other offenses more general for reckless behaviors with then 20 up to 25 million in fines. So again, very important, but the offense, the burden of proof is so high, but I don't even see how a procurer will be able to to build a case and win it in courts. But so how to enforce this? So good news is that for once, the draft provide for automaking powers for the minister. So for the reporting requirement, auditing, so AMPs, the criminal offense, etc. I would say it's quite unusual, especially when you look at the data and privacy protection in Canada. But one of the issue is that the enforcement rely on the minister, and it could be any minister designated in a regulation, but by default it would be the Minister of Innovation, Science, and Industry. But the Act provide that the Minister of Innovation may name an AI and data commissioner. So we have heard and we have been waiting for this infamous data commissioner for years. This is something that they promised in many documents, including in many budgets, often changing the scope of the purpose of such a commissioner. And so we finally seen this infamous data commissioner appear in a piece of legislation, except that this is not a commissioner. Like in Canada, commissioners usually are like independent agent of the parliament, such as the privacy commissioner. No, the AI and data commissioner, with quotes, is just a public servant. I mean, it's just like someone in the Minister of in ISED, if it's the Minister of Innovation that is in charge, like a high-level public servant that would be named as the AI and data commissioner that will have for mission to support the minister in the administration of the act, and so the enforcement, the order making, etc., which is questionable. That was quite a surprise. I'm not sure it's the best way forward for everybody to rely just on yet a service within the Minister of Innovation to have in charge like the designing of the regulation, and also like the enforcement of this regulation of that act. That's, in my opinion, problematic. And also it's kind of strange that in C11, so you have one bill with 3 statutes, but like 2 main well, actually 4 statutes, but like 2 main statutes. And there is no legislative consistency in the approach between the privacy, the new privacy reform, and AIDA. That is for the AMP, for the fines, for like the order making powers, not just in the amount and how it's the threshold are calculated, or even it's written in the act and other administrative, but even like all the enforcement that make no sense. And we end up with, like in C11, an independent agent of parliament that end up with less power, and that is subjected to a new, very strange tribunal. So he has less power than a public servant that is here to support a ministerial office. That is very strange, in my opinion. And also the reliance on criminal offenses and the public servants could be an issue. And it's not possible for the public to bring forth an action. This is also like in my opinion, a major gap in the act. There is no right to action, at least a civil basis for Canadians.
The terminology sounds the same when we talk about commissioners, but clearly there's a pretty dramatic difference between having an independent agent of parliament as a commissioner and having someone who works within the government serve in that commissioner style role. It sounds like a commissioner, but these things are not exactly the same, to say the least. All right. Well, before we wrap, the Canadian proposals are coming up in the context of course, other jurisdictions also thinking specifically around some of these issues. And for those that follow the debate around AI regulation, it's Europe that's really, the European Union that's really taken the lead. Can you compare how the Canadian system, such that it is, and I think anyone who's been paying attention here realizes that your description at one point of this as being roughly a shell that gives a bit of a framework with a lot of the coloring in still to come. But parking that to the side for a moment, how does the Canadian system, proposed Canadian system, compare to other AI regulation, particularly coming out of Europe?
Yes. So I would, as you mentioned, in my opinion, like contrary to what the government, said when they tabled C27, I do think that the EU is still leading the conversation. We may disagree in some of the provision and the approach in the EU AI Act, but I do not think that C27 is a piece of like thought leadership on how to regulate the digital space or AI systems. It's similar in the global approach is in the sense that the Kenyan approach adopt a risk-based approach. Like AIDA is a risk-based approach with, depending on the level of impact of your system, we understand that the rules will not be the same, that if you develop or operate, high-risk system, then you would have like more obligation, and the fine for violation would be like at a higher level. But without knowing more, it's very hard to very understand and compare both framework, because as you reminded a few seconds ago, like everything will be in regulation, and that might be one of the biggest difference in other proposed regulation or framework in Canada and abroad, or like usually the core piece include like the matrix, so. And in AIDA everything is still possible as long as you document. There is no option to maybe prohibit some system that would be too harmful. The scope is very restrictive. The public sector is not included. When like in comparison, the EU AI Act applies to pretty much like everything under the sun. There is like some exception, of course, but the basis is very like general, and then we build some exception, rather than like AIDA feels more like it will be an exception for the act to apply to a sector or to a system, rather than it will apply and sometimes you might be out of the scope. The other like big difference, as I mentioned earlier, is the EU AI Act provide an actual framework for all systems, as well as the analysis matrix, and proper definition. Sometimes it might be too much, and there's been a lot of criticism, and there is a lot of conversation in the EU about it. But at least there is like more meat to have a conversation and to have regulatory tools. None of this, as I said, is in AIDA, and everything will have to be discussed in regulation. And beyond, so Europe has been leading this, but we've seen like some proposals also in the US or like other countries, but even in Canada. So, on the conceptual framework, the Treasury Board Directive, so for the deployment and the use of automated decision-making system within the federal government, is way better designed. And even if, as like some flaws, ended up like proper enforcement mechanism, I think it was like a good approach with like impact assessment, etc. And it's kind of sad that the government that developed and adopted the Treasury Board Directive did not build on like previous successes that has been like acknowledged and celebrated around the world as kind of like a very good standard. That's very strange to just develop yet another approach to regulating the exact same subject matter.
So there was opportunities to build on some of the prior work that was foregone, opportunities to take a look at what takes place or has taken place in some other jurisdictions that was done at best on a limited basis. And while it sounds like you're supportive of the move towards creating an AI regulatory structure, I mean, to me, the overriding impression at the end of this conversation is that there's an awful lot of heavy lifting still to come.
No, exactly. And we can also disagree with the first part of the argument with the CCP, etc. But I think, and I disagree with a lot of it, but there is more like, more meat, more content. This is kind of missing in AIDA, so we don't really know exactly what would be covered, how it would be covered, but I think it's fixable. Like a lot should be changed, but like we need to have better definition. We need to have better scope. I wouldn't be against seeing more like a CPPA approach on how on how to define the scope. But yeah, we need to provide the key elements of the framework in the Act, not just in a regulation. In my opinion, we should also include civil remedies, as we have in other federal acts. So I'm fully aware of the limitation when we like in that kind of in between matters, or like there is kind of a cross joint jurisdiction over those issues, but civil remedies that could be considered as a right of action for Canadians seems like essential. And also I will end on this, we need to provide in the Act for whistleblower protection, with exception to the criminal code, because everything relies on documentation and information, and there is a lot of protection provision to make sure that we still protect confidential information and trade secrets. But we have also a provision in the criminal code that comes to protect trade secrets, and under this provision, anybody that will want to come to the minister to disclose confidential information, trade secrets that will show that that an AI system is causing like harm, even like high impact system, those people will not be protected under the current version of AIDA, and could be sued in criminal courts by the corporations. So that's yet another gap that I hope to see fixed when it will be discussed in Parliament.
Okay, pretty dizzying array of changes and work yet to be done. And glad to know that you'll be on the case and making sure that our elected officials are aware both of what's taking place globally, but also the room for improvement here in Canada. Florian, thanks so much for joining me on the podcast.
Thank you so much for the invitation. It was lovely to discuss this with you.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.